All right. Got the best part. Last week, we did an assessment. Sophia smiling because she was like, "What?" We did an assessment. It went very well. If you did not take the assessment, I'm going to drop that in the chat. Or if you are, good job, Helena, you can also use the QR code there if you're on a PC and you can grab it with your phone. I would suggest that you take this assessment really quickly just to get a baseline as to where you are with the buyer's brokerage agreement um, terminology, right? All right. So, ooh, go back. Go back too far. Why understanding the buyer brokerage agreement matters now more than ever? Of course, first of all, and again, we're not pointing fingers and we're not telling on anyone. Last week it was mentioned that not everyone is doing this. But let's make sure that we understand that execution of a buyer's brokerage agreement, one of them is required due to the NAR settlement. This is a requirement, right? And of course, you're tied into this by virtue of being with the local associations. The local associations have agreed to the rules of NAR, and NAR requires that a buyer's brokerage agreement be executed prior to the delivery of real estate services. Now, specifically, we know that the this requirement is specific to residential real estate purchase and sale. Residential purchase and sale. It's not required for leases. It's not required for commercials. Not required for those. But my question to you, my response to that would be, why not? Why wouldn't you? Especially once you've taken the time to review the agreements and you see how much it protects you and how much it lays out. It clearly lays out your responsibilities as a broker and the consumer's responsibility. Why wouldn't you? Right? People would do it. They're like, oh, well, it's not required for such and such. It's like, well, why wouldn't you? Right? Why wouldn't you want to make sure that you're covered? But because we want to make sure that we are clear in case it comes up, you do know that according to the settlement covered residential purchase and sale transactions only. Laura said facts. Now, it's also important to understand it because now that it must be executed, um, good, Della, that's good to hear. Um, Now that it must be executed for purchase and sale purchase agreements or purchase transactions, you got to be able to explain it, right? If you have a pretty savvy or just a professional customer, you slide in front of them a 3-page document, I would with a, you know, single, what do they call it? Single font, single line spacing, bolded throughout lines and dots and checks, and they just sign it. It happens, but more than likely they're going to ask some questions. And so, with that being said, you have to be able to answer their questions. And then, lastly, understanding the buyer's brokerage agreement is necessary because you need to define your enforcement protocol. What does that mean? That means how are you going to ensure that you get paid? Later on in our discussion today, we're going to talk about a lawsuit. I would proffer to you that you should not get to that point. I would proffer to you that there are mechanisms to avoid having to enforce your compensation via a lawsuit. We're going to get more into that in next week's session because we're going to talk about some language that could be added. I won't necessarily say should or must, but some language that could be added to the buyer's brokerage agreement, and it can absolutely be added to the compensation agreements, right? As you start negotiating transactions. But those three things you must know. Number one is required due to the NAR settlement. You mentioned that her brokerage requires it even for leases. So think about it. There's a number of different um, checkpoints, right? You have the NAR settlement that requires it. Your brokerage probably has some compliance checkpoints in place, right? That you're not getting paid unless they see that this buyer's brokerage agreement was executed, right? And so you have the law and then you have compliance with your brokerage. And so for that reason, you should be got to know how to work with this document, right? So you should know also that there are various forms of brokerage relationship agreements. So the Florida brokerage relationship agreements are listed here on the screen. So we generally have the property pre-touring agreement, right? That is the least form of protection for you. It is a very we describe that as if someone finds a property on Zillow and they call you to show it. Because you know more, if nothing else, showing a property, opening doors virtually or in person, that is the that's it. That is, you have hit the mark for you must have an agreement executed, right? So property pre-touring agreements, that's where someone says again, I just have this one property. Della, can you just show it? This is it. Like this it. Nothing else. I don't want. Can we quickly do this? And they've made it clear that, oh, I heard about that long 3-page agreement. I don't want a long 3-page agreement, but I know that you have to have something signed. So can you show me this property? And you say, okay, you know that you have a property pre-touring agreement that you can utilize. But again, that is the least form of coverage for you. Then you have the showing agreement. The showing agreement, you are going to lay out specific properties. Let's say they have um, 3 properties that they want to see. That's it. I'm coming in town to see these 3 properties. If these 3 properties don't work, we'll try again next season, right? And so you have the showing agreement. And then you get to the longer form agreements, which is your exclusive buyer brokerage agreements, right? And these are generally about 3 pages. And what I'm showing you here on the screen is that there are 3 types of exclusive buyer brokerage agreements. You have the single agent. This is where you're telling the buyer, I am only working with you. There's no situation where I will work with you and the seller. I'm a single agent. I'm operating in one capacity on this transaction. And then you have the transaction broker agreement, which is the agreement that we are going to look at today and next week because it's the most common form of agreement. I've had agents say, I never do both sides of a transaction. That's your decision. That's your business decision, but you can, right? And so if you're doing that, you're using the transaction broker agreement. And then you have the no brokerage relationship, but it's exclusive. The difference with all of these is the fiduciary duty that you have. Single agent, you have the highest form of fiduciary duty, the highest form. My allegiance is to you. Transaction broker, my allegiance is to the transaction and protecting, and still I'm still protecting you. No brokerage relationship, I just must get this signed. We're just making sure that we legally cover what's necessary. I don't really have to do anything for you to protect you. I do have to be professional, right? I can't violate a code of conduct or ethics, right? Another way for you to understand this, and I use this example oftentimes, is similar to the purchase and sale agreement, right? You guys know that we have as is, we have a CRISP. The CRISP, it has baked in agreements for repairs to the property, right, and the condition of the property that the seller will comply with versus the as is. As is, you're purchasing the property as is. So look at the buyer's brokerage agreements in that form. You have a inventory of different agreement types that you can use. You should know that. For the purposes of today's discussion, next week's discussion, we're using the transaction broker agreement. All right. All right. Yeah, you can. So in the chat, it's mentioned that there is use of office specific forms, which you can do that. When we conduct these trainings, I'm glad that was mentioned as well. Know that when we conduct these trainings are the baseline. There are brokerages that have heightened requirements, such as their own form of agreement, or they may have riders, or for example, when we talk about compensation, there are brokerages that do not allow for compensation to come from the other brokerage, right? You know that you have seller or broker to broker compensation, and you have seller to broker. There are brokerages that do not allow broker to broker. they require seller to broker because their position is that is the entire crux of the lawsuit, right? Um, Transparency and the seller being aware that you're paying the other broker's compensation. And so for that reason, there are brokerages that do not allow broker to broker. They want seller to broker, right? So with that being said, when we get on these trainings, this is the baseline. This is the baseline requirement. If your brokerage requires something in addition to that, then you absolutely must follow what your brokerage is requiring. All right. All right. Um, Go ahead, guys. Keep putting drop your questions in the chat. I'm gonna wait until we get to the end, unless I could hit it quickly, but just to make sure we stay on schedule, I'm gonna save questions to the end, but drop them in the chat so you don't forget your questions. All right. So you should know that the brokerage agreement is similar to an exclusive employment contract, right? Um, they are hiring you to perform a service for them, right? Which is find them a particular property. It is a binding bilateral contract governed by Florida law. It's binding. This is a contract. So again, similar to when we take the contract class, and I tell you guys when we first start out, this is a contract. If anything goes wrong in this transaction, there are enforcement terms that could lead to litigation. So same thing here. You have a responsibility to the buyer has a responsibility to you, right? It is binding. And courts are going to enforce these agreements just like any other service agreement. Similar to the purchase contract. I tell you guys that too. Just because your client, in the event your client did not utilize an attorney to assist them in drafting their offer or accepting the offer terms, court doesn't say, oh boy, they didn't use an attorney. They didn't know any better. No, right? That's it. They're going to enforce it the same way. Um, so let's look at the sections of the exclusive buyer brokerage agreement. In the chat, again, I just dropped a hyperlink to the exclusive buyer brokerage agreement. And then we are going to review section by section here on the screen. So section by section, again, remember, you just need to know where to go to find this information in the agreement, right? Know the lay of the land. I think of it even like your house. You may not know exactly where the lotion is, but it should be in the bathroom, right? I mean, that's a pretty common thing. So you may not know exactly what the terms section says, but you know where to find it on this agreement. So the parties, consumer and broker. We use the term consumer. It used to say customer. Now, when the form was updated, the language is now consumer. So consumer and broker are the parties, right? Section 2, the term, what's the start date and the end date? What have you guys agreed to? How long is this um, brokerage relationship in place for? 30 days, 60 days, 90 days, 180 days? Hopefully not, hopefully not much longer, right? You're trying to close sooner than that. And so you also know that looking at the last line, that the agreement will continue in effect until the transaction has closed or otherwise terminated. So that means if you go under contract, say for example, this is set to expire, today's February 12th, right? Yeah, February 12th. Say it's set to expire the 12th. You're under contract to purchase the property, or it's set to expire the 13th. You're already under contract to purchase. That contract is not closing until the 17th. That means that this is going to continue to cover you until you close on the 17th, even though it's set to expire tomorrow. All right. Section 3, the property type and location. What type of property are they looking to purchase? I wouldn't say any, right? It should be broad enough to cover various property types, right? Single family, multifamily, right? Duplex, you might consider that. So condo, you can use that type of description, but residential property, single family residential property, condo. Now, location. This is another one. It depends on your strategy. Now, some of you may say Florida. Well, here's the deal. If you say Florida, you better mean Florida, right? Meaning if that buyer finds a property in Gainesville, go Gators, you need to go show them the property in Gainesville, because if you do not, now you have an enforcement issue. If they see a property in Gainesville, you don't show them the property in Gainesville. They go and they find someone else to show them the property in Gainesville. Now we're having a conversation as to whether or not you truly can enforce this term. You knew you couldn't go uh in the Panhandle. You live in Miami. Are you really going to show a property in the Panhandle? Right? Now, if you say, for example, we're Ray Cole, I have a network of agents in all, what do we have, like 67 counties, that wherever they want to see a property, I can show it. That's it. I have showing the system. Well, then have at it, right? But if you don't have that, then let's make sure that we have the scope of the location to where you know you can provide services. All right. Then the next section, broker obligations. You guys should have the agreement in front of you. Now, one thing I want to say, because we're not going to go over this line by line per se, but in these next two sections, if you're looking at the agreement, paragraph 4 and 5, before this agreement was a required document, I want you to think to yourself, how were you documenting your responsibilities versus the consumer's responsibilities? Kind of just winging it, right? Telepathy, like they know it, common sense. I mean, they know I can't, you know, only show them homes in this particular, I can violate fair housing. They know I can't violate fair housing. How would they know that? How would they know? Right? How would they know that, for example, in the broker's obligation sections, it says that you can work with multiple buyers for the same property, and then and there's no harm, no foul. So this is one of the things that I love about this written buyer's brokerage agreement. And again, just think about your world before this was a requirement to sign, right? No guarantee of third party services. Look at subparagraph D. Broker does not warrant or guarantee products or services provided by any third party whom broker at consumer's request refers or recommends to consumer in connection with the property acquisition. So let's say, for example, we commonly refer the buyers to what? Inspectors. You give them three, but even still, that just so happened that one of the three does a terrible job. Well, this document is clear. I don't warrant their work. And you agreed that I don't warrant their work. Prior to having this signed, where was that in black and white? It wasn't, right? So this is not so bad after all, right? Consumer obligations. This is where we get real meaty. We get real meaty because subparagraph A of paragraph 5 is where it lays out exclusive working relationship with you. You. For all of their real estate needs, all their real estate acquisition needs during the term of this agreement. All right. So let me make sure I explain this to you clearly. Prior to executing, prior to you utilizing this buyer's brokerage agreement, I guess you just assumed that the buyer would be loyal to you and exclusively only work with you. I mean, I know you hope that they would, but there was nothing in black and white that required them to and made it clear that that was their responsibility. There was nothing that specifically told them that. Yes or no? If you did not use a buyer brokerage agreement, how would a consumer know? How would a buyer know that they're supposed to only work with you? I definitely don't see any commercials going around saying, when you start working with a realtor, That's the only person you should work with. It's not fair if you go to someone else. Like, I don't see that, right? And so is this agreement lays it out very clear that this is an exclusive working relationship with you. Now, one thing I'm gonna read 5A because I want you to see how clear it is that during the term of this agreement, however they come across this information, they come across the property, yeah, they need to work with you. That's what it says, right? So look here. 5A, consumers' obligations. Consumer agrees to cooperate with broker in accomplishing the objectives of this agreement, including conducting all negotiations and efforts to locate suitable property. Gotta mute somebody right here. Right quick. Second. Oh, oh. Conducting all negotiations and efforts to locate suitable property only through broker and referring to broker, that's you, all inquiries of any kind from real estate licensees, property owners, or any other source. If consumer contacts or is contacted by an owner or a real estate licensee who is working with an owner or views a property unaccompanied by the broker, open house, new construction, consumer will, at first opportunity, advise the owner or real estate licensee that consumer is working with and represented exclusively by broker. That's some beautiful language. Kudos to Florida Realtors for that one. That's beautiful language. I don't know about you guys, but that's beautiful language. That's beautiful language. That says, however you find out about this property. However you find out about a property that you're interested in, you need to come talk to me. Come talk to me. 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 All right. So next week we're in consultation land. This week is for you to understand the language. Next week is for you to be able to explain the language to the client, to the customer clearly. And they should know the courts do not exclude they do not excuse failure to read the contracts, and they don't excuse a client saying, I didn't understand, right? Now you want to explain, you want to make sure that you explain it well, but once you've done that, you covered your bases. And so what this paragraph is saying, consumers not saying, oh, I didn't know I couldn't do that. Ooh, I didn't know. I didn't know I couldn't go to an open house and work with the agent who was hosting the open house. I didn't know that. I didn't know I couldn't go to a new construction community and not tell them that I was working with an agent, right? We all know how new construction works. They're going to have you sign in and all these other things. And here's the deal. Del, I see your question. Here's the deal. You have to explain to the customer that unless, and I use very extreme examples, unless the new construction community is saying you absolutely cannot come in here unless you work with us or something, some type of, I don't want to use the term coercive, but forceful language, they have a duty. You have a duty to tell them, well, I don't know what's all in this document, but I am working with a broker. Her name is Idiotti. Sorry, like, right? What's your question, Della?
Okay, so with that being said, when like I said, our brokerage require us to do the agreement with leases, and a lot of times I get they want to look at a property, but they're looking at properties with another agent. And when they call to ask about seeing a rental, I will tell them that, it's a required form that I have to have them to sign in order for me to show them the property. They'd be like, oh, yeah, okay. But then yet they're still working with somebody else.
So that doesn't work. That doesn't work. That doesn't work. number one, you're not showing them the property to be their buyer's agent though. All right?
Well, okay, for the most part, it's when I have a listing.
Right. So that's what I'm saying. You're not trying to represent them as their agent.
Okay. So with
Yeah.
that being said, if it's my listing, then I don't have to have them to sign it.
No, you're not trying to represent them as their agent.
Okay, I got you.
Mm-mm. You're not trying to represent them as their agent. Opening the door. You're not trying to represent them. That's the same thing as having an open house.
Okay.
Remember, you don't, I didn't put that in the assessment, but I wanted to use it as that because it comes up often. When you're holding an open house, you're
You just
not, oh, exactly, you're holding the house open. You're not providing real estate services specifically to that customer.
okay.
Now, if, for example, you're holding an open house and there's an open house across the street, and the buyer says, Della, this is nice, but can you take me to go see this one over there? Now you are providing a service.
Okay. Okay. So then that's where I'm sorry, I didn't mean to cut you off.
Yes, you need a
So
buyer agreement.
okay, so if they don't have an agent and they want to see it, then I have to have them to sign it when they want to.
Yeah, because at that point, you should be trying to be their agent,
Right,
right?
I got it. Okay. I guess I answered my own question. I just wanted to be clear though.
No, that's a good question. And trust me, literally, we've heard all our lives, and there's no stupid questions. You'd be surprised how many others have the same question. All right.
Okay.
All
All right.
right.
Thank you.
No problem. Thanks for the question. Let's jump down to paragraph 6, retainer. You can charge a retainer. That means you can charge a fee to work with you. You can charge a fee to just engage you. You can charge a fee to get you to put them on your list of clients and start sending them stuff and cranking up your car or charging your car, gassing up your car. You can charge that, and it's non-refundable, and that is earned at agreement execution. So when they sign the agreement, they slide the check, the Zelle, or however is required, right? Um, Now this is, again, like I said, this is separate from your commission compensation, and you you should confirm this with your broker, right? Because we know that all fees are to the brokerage. Unless you are the broker, meaning you are the broker owner, all fees belong to the brokerage. Everything even the listings, right? Listings belong to the brokerage. And so if there's going to be any retainer fees collected, then you need to confirm with your managing broker how that is going to be resolved. So for example, I had a broker that indicated, I don't have a problem with my agents collecting a retainer fee. They can keep all of it. I just need to figure out the pass through, right? This is when it first came out. I just need to figure out the pass through situation, like how to, for my own bookkeeping and record keeping requirements, when it's paid to the brokerage and making sure it gets back to my agent, right? So when it comes to retainers, you want to make sure that you confirm that with your managing broker. Do not accept a retainer fee paid to you directly across the table. Do not, right? Um, The next section, and I see your questions. We're gonna make sure we get through and I'm gonna answer your questions at the end. Drop in the chat. Is compensation. That's the hot spot. Compensation earned trigger is a major hot spot. This is the single most misunderstood provision, and this is where most disputes originate. Now, for this, I am going to we're gonna pull up the compensation agreement, just this section of it. Let's admit some people. All right, let's put this up. We're gonna put this on the screen. So we can see this big. All right. Compensation. Last week, last week, this is where I think if you didn't get 100, everybody got at least this one wrong. So we're gonna put this on the screen. I want you to know that compensation is earned when during the term of this agreement, this your buyer's brokerage agreement, or any renewal or extension, consumer or any person acting for on behalf of the consumer contracts to acquire real property as specified in this agreement, or if they default on any contract to acquire real property, your compensation is earned, not necessarily paid out right then, but you have checked the box to earn your compensation. You have checked the box to earn your compensation when you accomplish this, right? This compensation is for your services. It is you are going to make sure that the any amount that is paid to you, I think this question was asked as well last week, and this describes it. Compensation received by broker, if any, from an owner or owner's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph. In other words, compensation received by broker from any seller or seller's broker for services rendered to consumer will reduce any amount owed by consumer per this paragraph. So that means, again, let's say, for example, this agreement says that the buyer is going to pay 3%. The seller has agreed to pay 2%. The buyer is now must pay what? 1%. If the agreement is for 3%, seller's agreeing to pay 3%, buyer owes you nothing because it's offset, right? The portion that we have highlighted though is that you are clear that when that buyer finds a property that they're interested in or their representative, meaning, you know, an attorney or someone that's acting on their behalf, you have checked the box, ding, 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 your compensation is earned. Again, enforcement of it and how you're going to get paid is the separate conversation, but you should know that you've checked the box. Legally, you need to know this. This is your agreement. Because many agents thought, oh, I mean, you might not receive the payment until you close, because that's when monies are exchanged, especially if it's coming from the seller's proceeds. But know that you've earned your fee, right? And this should be communicated in your consultation, right? So this brokerage agreement contemplates various types of transaction. We have our purchase or exchange, a lease, purchasing it, an option, and then other, right? And then here you can place additional fees. Additional fees could be what? Your transaction fee. Prior to the buyer's brokerage agreement, agents would just complete their intake form and put a transaction fee on there. And the buyer's like, what is this $395? I never agreed to that, which they did not, right? That's not something that you just customarily put on your intake sheet, and then you can't enforce that against the buyer if they never agreed to it, right? So before the buyer's brokerage agreement itself was a requirement, that was almost we call it the canary in the coal mine of enforceability concerning compensation to agents. You were putting $395 on your intake form, but there was nothing in black and white for you to enforce that requirement to be paid. So that an additional fee section can be your transaction fee, administrative fee, whatever you call it, right? Your water fee, you put water bottles, whatever, right? Dropping down here to 7A, the other section that I highlighted here for you guys to be clear on, and this is on the handout as well. This compensation is payable no later than the date of closing specified in the sales contract. However, clap it up for Florida Realtors. Closing is not a prerequisite for broker's fee being earned. I'm going to say that again. Closing is not a prerequisite for broker's fee being earned, meaning buyer goes under contract. Buyer defaults. You don't have to close, but I'm still due payment. Here's our wire instructions, right? Again, about 95% of you are like, I mean, okay, yeah, but how does that even work? We're going to talk about that, but you still need to know that that is a requirement because this still needs to be clear to your buyers. Now, of course, you don't have to lean in on it for 30 minutes the way that we are, but you want it to be clear because you want them to make a good faith effort to close that transaction, right? And when we talk later about strategy, they need to know why it's important that they may want to only look at properties or make offers on properties where the seller has agreed to compensate you for your work, right? Meaning, if the buyer's not clear that you owe me 3% unless someone else pays it, then they may or may not be pressed about negotiating only with sellers that are willing to compensate you, right? May, go ahead. What's your question?
Hi, Nick, Raghu, thank you. My question is like if the property is a new construction, it's gonna finish 2030 in next 4 years. So the builder give half of the commission now, and then next 4 year, if happen the buyer can close it. So in that case, like the agent have to refund the money or keep the money.
So that's a good question. It depends on the terms of the agreement with the builder. More than likely, the builder is going to say that they must receive that money back. But assuming you have a proper buyer's brokerage agreement in place, you should have that money available to because you're going to collect it from the buyer, right? Now, of course, this is all you have to collect it from the buyer. Let's you have to collect it from the buyer, whatever that means.
Not
You got
from the
really
buyer,
pay
from the builder.
in order to get it to the builder in the event that they don't close, right?
Mm-hmm.
Does that make sense? So again, for the purpose of our conversation today, you need to understand the framework. You need to understand how it works. Now, how difficult it may or may not be to accomplish this, that's a different conversation. But just know that the agreement is written for this to happen. Does
Thank
that
you.
answer your question?
Yes, thank you.
Perfect. Good question. Right. Um, so that's the compensation section. That's the compensation section. Now we're going to go back to the slides really quickly and we're going to come back to that just shortly. But let's go back here and finish up compensation. All right. Hmm. Why is this? Hold on one second. Doop, 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 doop. I swear I need like 4 screens. Share screen. Let's go back here. All right. So recapping the compensation section. Compensation is earned at contract execution. Compensation is earned when the buyer executes contract to acquire property. Do not assume that no closing equals no commission, that you're not entitled to it. Again, enforcement, we're going to talk about that. We know that closing is not required and it applies even if the buyer defaults. What does that mean? Let's say, for example, the buyer, they're financing. They don't get a clear to close and they don't get a clear to close because they went out and purchased a new BMW. Oh my God, that's your default, right? Because paragraph G says you're going to make paragraph G, 5G of their responsibility says they're going to make diligent effort to perform the contract terms to complete their closing. They're going to do everything that they need to do. So meaning that if they default, that does not mean that you're still not entitled to your compensation. All right. Ooh. Now, the next section is protection period. Protection period after the termination of this agreement defaults to 30 days, right? Now, this provides for you to be compensated if the consumer contracts to acquire any property which was brought to their attention during the term of the agreement. All right, let me show you something. Now, on the screen, drop down here to paragraph 8. Here's what I have issue with. The part that's highlighted. Consumer's obligation to pay broker's fees ceases upon consumer entering into a good faith exclusive buyer brokerage agreement with another broker after termination date. Why do I have issue with this language? Before I say it, let me see if somebody can tell me why I have issue with this language. JR, you're in here. You should know this.
Is it because if they get with another agent and then they go purchase a property that you show them, then that kind of insinuates that they don't have to pay you?
That's exactly right. That's exactly right. That's exactly right. I've said this before. I'll go on record saying it. I don't know why this language is in here. It's completely unfair to the broker. Similar language is in your listing agreement. When we talk about listing agreements, we'll hit this. This is unfair, but it's in here. Because it is in here, you have options. Strike through it and add language that addresses it, or additional term language at the bottom. That language we'll talk about next week because again, we want to stay within our time allotted today, but I did not, because we're reviewing it, I wanted to highlight it in your handout. You also see this language highlighted. Not a fan of it. Jocelyn, you got a question?
Yeah,
Were you going to ask how to?
You just asked me a question. I was going to say, can we
Okay.
extend it? Yeah, extend the term.
Maybe not even necessarily extend the term, because you don't want to just keep extending, but you can add language that covers you for properties that you've shown them or brought to their attention during this period, even if they go work with another agent. Does that make sense?
Yes,
I,
thank you.
I do not agree with this language. I will go on record saying I do not agree with this language in the buyer's brokerage agreement, also in the listing agreement. It says the same thing in the listing agreement. It says that let me see if I have it highlighted here. This one.
But Ray Cole, wouldn't the protection period still offer some sort of barrier from that?
Yeah, that's the question I have. I don't understand, because it says the first paragraph you have 30 days, which you can change to 180. So it's one contradict the other.
No, they don't. You could think that you could arguably say they contradict, but they don't. That language, that last line cancels out is the way it's interpreted.
Oh.
It cancels out. Yes, it cancels out. So only because I have it up here on the listing agreement, it says, the language says, however, no fee. It has the same language about protecting the listing agent, but then it goes on and it says, however, no fee. However, no fee will be due to broker if the property is relisted after termination date and sold through another broker. What? Nah. Why do I have a protection, right? Because, and this is specifically not just that, and again, we're not going to go too deep into this, but here's what I want to tell you guys. You want to tighten that language, because what can happen is the property not just be relisted, but is relisted and sold to a buyer that you were already working with before the listing expired. It happens, unfortunately.
Isn't it sometimes too depends on, I guess, the verbiage of a contract? You're still obligated, even if like a protection period, even after it expires?
Well, that's what I'm saying. The language here cancels it out.
Oh, okay.
It specifically says, however, no fee will be due broker if the property is relisted. Like, for example, in the listing agreement, no fee is due if the property is relisted at the termination date and sold through another broker.
Mm-hmm.
So, to recap concerning the protection period, it defaults to 30 days, and then you allow for a conditional termination. So you can conditionally terminate this agreement. Go back to our buyer's brokerage agreement, this conversation at hand. You can conditionally terminate the agreement and you can have a cancellation fee, right?
Mm-hmm.
However, this language is also good. It says that, Luckner, I see your question. Give me 1 second. So at consumer's request, paragraph 9, broker may agree to conditionally terminate this agreement. If broker agrees to conditional termination of this agreement, consumer must enter a written agreement to this effect, meaning a conditional termination, and pay a cancellation fee of whatever your fee is. Broker may void the conditional termination and consumer will pay the fee stated in compensation, which is paragraph 7 above, less the cancellation fee if from early termination date to termination date plus the protection period, consumer contracts to acquire any property which prior to the early termination date was found by consumer or called to consumer's attention by broker or any other person. What does that mean? That means you and allegedly, I say allegedly, you and the buyer just cannot make an offer. You've seen 30 properties in 30 days and they're just, you decide, you know what, we just don't match. You still have another, 180 days on your agreement, but you guys decide to early terminate, all right? So you early terminate and then, oh, all of a sudden you're interested in the first property that I showed you on day one, right? That means, I'm due compensation, right? And if they pay the termination fee, whatever the commission is minus the termination fee that you paid. All right? That's what that means. All right. And I mentioned here strike through unfavorable terms, right? So dispute resolution, paragraph 10, Florida law is going to govern if there's any dispute concerning this contract. You're going to go to mediation first. Similar to the purchase and sale contract, you go to mediation first. Mediation is a neutral third party that's going to hear your side of the story. Here's the buyer side of the story. They're going to make a recommendation of how you should resolve it, but nobody's required to follow their recommendation. That's what mediation is, right? Neutral third party. What do you say happened? What did you say happened? Well, according to the law and the facts, I think this is how you should handle this, right? You will go to litigation if it's not resolved. However, you see that you can agree to arbitration. Arbitration is the same setup as mediation, except that neutral third party actually makes a decision. It is not a recommendation. They make a decision on the case based upon the law and the facts that are presented. Oftentimes, folks will agree to arbitration just because of cost, right, and efficiency. Litigation, you're picking a trial, a jury or not, depending upon how the case is filed. You're going to trial, all these other sorts of things, and it's just a longer drawn out process and it's more expensive. Versus arbitration, again, you go meet in a room, neutral third party, present your facts, arbitrator makes a decision, right? So that's dispute resolution. And you guys should really know how to describe that for someone as succinctly and clearly as that, because that's in their contract. That's in the purchase and sale contract. It's clearly also here in your buyer's brokerage agreement, and it's also in your listing agreement. So these three frameworks as dispute resolution, at least when it gets to litigation, are in most of your agreements. Of course, when you get to concerning escrow disputes, there's a different framework that comes before this. But when it comes to legal disputes, the majority of our agreements say mediation first, litigation if you can't resolve it, arbitration if you agree to arbitration instead of litigation. All right. All right. To wrap us up, we have one of our first cases on the buyer's brokerage agreement. Echo Fine Properties in December of last year, there was a lawsuit. Echo Fine Properties sued a buyer for not paying the compensation. They avoided, they sued the buyer for breach of the contract. The buyer attempted to avoid compensation. So here's what happened. Buyer signed an exclusive agreement with Echo, but later bought an $800,000 home using a different agent. The arbitrator found the agreement unambiguous, meaning this language is clear. This language is clear that you agreed to work exclusively with this broker for any purchases during this term. You didn't do that. You went and purchased the home with someone else. So they ordered the buyer to pay a $24,000 judgment. I think that's
So
pretty
how
good.
did they find out that they end up with buying a house from another agent? They was keeping track of
Yeah,
their
they saw it. Yeah, yeah. So this is good. This is good precedence. We call this precedence, meaning this is good. Right? This says that the courts are going to enforce these agreements, right? So the court ruled in their favor, the arbitrator ruled in their favor because of the language. Again, the language is, we call it unambiguous. It's clear, right? The buyer's conduct and then the broker's performance. So remember what I told you guys earlier about putting, placing that the scope is Florida, and then you go and can't show a property in the panhandle. Well, you shouldn't have done that, right? Let's make sure that we keep the scope tight. All right. Okay, see you later. And then this highlights three key lessons. One, the court is going to enforce the plain language of the agreement. Buyer dissatisfaction does not mean they can just terminate the contract. Of course, you guys have the ability to discuss termination, but it does not automatically terminate the contract just because the buyer is unhappy, right? And documentation of your services matter. So again, this case sets precedents that buyer brokerage agreement are no longer symbolic, they are enforceable, and they will be litigated accordingly. They will be litigated accordingly. But again, the thing I want you guys to understand is that I don't want you to have to litigate it. Because it's number one, it's more time, more money. You're expected to get paid at closing. It's more time, more money. And of course, no outcomes are guaranteed. We know that the agreement is clear, but no litigation is ever guaranteed. Don't let an attorney ever tell you about a guaranteed outcome because that does not exist. All right. And so again, when we get into next week's conversation, we're going to talk about some strategies around making sure that you don't get into these enforcement conundrums. Okay. So best practices, you want to review the key paragraphs thoroughly with the buyer. Make sure that there are no surprises later on. Because here's the other thing. Litigation and disputes, they just don't look good for you either, right? You don't want to leave a bad taste in someone's mouth. You just never know how far someone's going to go with their retaliation against you for a bad experience, right? And again, you could have been right, and you are right, but is there a way for us to avoid disputes is what we want to make sure that what we look at, right? Next week, when we talk about when we go over the document, here's the thing here. You want to agree on on a commission strategy. Is it going to be buyer compensation only? This is important. And I'm going to keep reiterating this. I think you guys understand it by now, but when this agreement first came out, I don't think it really clicked. When that agreement is executed, the buyer has agreed that they're going to pay you. This 3%, 2%, 2.5% is now an additional closing cost. They need to understand that, right? Is the strategy going to be seller compensation only? Buyer says, hey, listen, I understand that I have to execute this agreement and we're going to agree how much I expect you to be paid. I would like you to be paid, but we need to also agree that we need to ensure that we negotiate to go into contract for proper only in circumstances where the seller is going to cover all of your commission, right? And that can happen. Or what if the buyer says, I got a little bit of cash, not a ton, but I had a little bit that I could contribute towards your commission. And so keep in consideration, I have this much to allocate towards your compensation. And in the balance of it needs to come from the seller, right? So you have different compensation strategies. And you want to document the compensation contingency. Again, if they say only show properties that the seller's offering compensation, or buyer's only going to go into contract where seller is going to pay buyer's commission, document it. All right. All right, Dominic, no problem. I'm going to ask questions just shortly. So recap, exclusive relationship, exclusive. They're working with you only, right? And establishes your obligations and the buyer's obligation. Compensation is earned at execution of the contract, right? Know about your protection period after termination. Be clear on your protection period, and then be clear on dispute resolution. Again, when I signal dispute resolution, what I'm signaling is, do you make sure that you know how you're going to get paid? All right. Questions? All right. Let's see here. Got a lot of questions in the chat. Ooh. All right.
The only question I have, Rico, how you doing? How's everybody?
Hey, how are you?
Question I have, I think you most likely already answered that, but most likely you have a buyer working with you. Even you make them sign the buyer brokerage agreement with you, they go behind your back and use a different agent, buy their own property. I have a few, customer did that to me last year, which is one of them. It's really not really my friend, but this is a guy I know, I trust.
Okay.
Next time I call him, I send him an email. I said, I have a nice lease of property I want to show you. He started laughing at me. Hey, brother, let me call you back. Later on, he called me next hour. He said, why buy a mansion in Palm Beach Garden? And I'm sorry because there's a guy convincing me. I said, well, you know what you signed with me. 6 months ago, we've been driving around, show you property. We
Mm-hmm.
waste a lot of time. So a person like this, so what should I do with that person? And he signed the
What
buyer
y'all
brokerage
in the
agreement
chat?
with
What
me.
do y'all think? What should he do?
Well, he signed a buyer brokerage agreement with me and he went and buy a big property in Palm Beach Garden. And he
Okay.
telling me, oh,
Arbitration. Arbitration.
okay, well,
What she's saying is file a lawsuit. That's what she's saying.
yeah.
Go
So,
ahead. See. But see, I'm glad you asked that question. This is why we're going to have
mhm,
a conversation next week about strategy.
okay.
Um, Again, in that case, you have no choice but to file suit and qualify your buyers. Yeah, in that case, you have no choice but to file suit. A worse situation is when you solely rely on the buyer's brokerage agreement and they do close, but they decide at closing, oof, Luckner, my math was off. Sorry. I
That's
don't
okay.
I don't really, no. I'm saying the client says to you, oh no,
Mhm.
my math was off. I don't really have that 15,000 for as an additional closing cost. But we're gonna go ahead and close and I'll get back to you, okay? Bye. You guys understand what I'm saying right now?
I do understand. But
What
a
I'm saying,
person like
what
a
I'm saying,
person,
hold on one second. Let me finish this because this ties into next week. What I'm saying to you guys is the buyer's brokerage agreement alone does not prevent, she says in the
a,
payment plan.
a buyer.
Buyer's brokerage agreement alone does not prevent a buyer from closing on a purchase and you
Mhm,
not being paid at closing.
mhm.
This is why I hinted at the beginning your enforcement strategy. Your enforcement strategy needs to put a stopgap between that buyer and that property because the buyer's brokerage agreement alone does not prevent them from closing. There's nothing that's going to stop the closing agent or the seller from proceeding to closing without you being paid. I just made somebody's head spin. That's a preview into next week. That's a preview into next week. If you don't
Okay.
understand, make sure you're here next week. But
I'll
you
be on.
understand that. That's why I keep signaling at how are you going to enforce that you're being paid? The buyer's brokerage agreement alone does bind them to a contract. Now you have something to enforce. But what I'm telling you guys is you don't want to have to enforce in litigation, right? You want to figure out how to enforce how you're going to be paid at closing. And again, that's next week class. But in the case of this gentleman that you're talking about,
Yeah.
oh, yeah, absolutely.
Okay.
Um,
Thanks.
no problem. Question. Go ahead, Joanne. Oh wait, Candace was up first. Candace first. Go ahead, Candace.
I have put it in the chat. Can you hear me?
Yeah, I can hear you. Let me
Okay,
see.
great. I put it in the chat and I don't know if it got deleted, but what's your guidance for a listing agent when non-represented buyers reach out and they are adamant that they're not signing anything, but they want to see one of the listed properties that you have in your inventory?
You let them see it. You're not providing services, though you're not representing them.
Okay. All right. Um, I
That's just like
typically,
you can't force someone just like we can't force someone to use a realtor to sell their property. We
Mhm.
can't force a buyer to utilize a realtor to see a property. Does that make
Okay,
sense?
no, yeah, it makes sense because they were like, "Oh, you're the first person that's asked me to sign anything, and I'm not signing anything, and yada yada yada." So, I
Yeah,
typically, in
I'm
order
going to
to
tell
show
you guys,
property,
unfortunately, and that's a whole nother conversation. You guys know that there's a lot of platforms out there that are encouraging not just
to not
buyers, but
use an
also
agent, yeah, to leave the agent out.
correct, 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 correct. And you can't force them to I mean the best thing you can do, let's say for example, going back to what I said before, this is baseline. Maybe your brokerage says, well, we don't want any blur, and they come up with, like Ediana mentioned, maybe they come up with a disclosure that says, I don't represent you. I'm just to be in compliance with NAR settlement. I'm using generic terms, right? So this does not create any agency relationship. This is just so that you confirm that I don't represent you and I'm only allowing you access to the property. Your brokerage might come up with something like that, but that's a very good question. But do understand that if someone comes to you and say, I just need access. I don't need you to do anything else for me. I'm going to write up my own offer, right? They can do that. Who was next? I see Joanne, Monique, and Ediani. Ediani,
I
your hand?
was, is there a statute of limitation on the arbitration on filing a lawsuit?
There is a breach of contract. Yeah, I want to say it's like 5 years. I'll have to look at it specifically. I'll have to
Okay.
look at the statute, but breach of contract is generally about 5 years from the time that you became aware of the cause of action, the ability to file a cause of action.
Okay. Thank you.
Yeah, good job. Monique, question.
Yes, great afternoon, Nicole. I'm not sure if you mentioned it because I ended up having to step away for a brief moment regarding the compensation. So when you're doing new construction, is there something, and if that's what you're going to touch on next week, then you can just bypass the question. But is there like when they're giving like bonuses and things like that, how does that work when it comes to the agreement?
That's a good question. So we are going to touch on it, but just to give you a preview, there's a couple things you can do. One, if you contemplate that they're going to look at new construction, then in your additional terms section, there's language that you can add that says that, of course, you won't know the exact number, but you can add language that says if the buyer negotiates to go into contract with a property that has a bonus or additional compensation, buyer agrees to execute a modification of buyer's brokerage agreement, something along those lines. Or the other is, like we talked about before, they see a property, the seller, whether it's new construction or a resale seller, they're offering compensation above that which the buyer has agreed to. You're just going to do a modification to cover it.
Okay.
right? So
Gotcha.
you go to new construction, it's like, oh, we're giving a $5,000 bonus. Okay, you need to make sure you're doing a modification to your buyer's brokerage agreement to cover that $5,000 bonus for that project.
Okay, so it still falls back on having to do a modification to the agreement.
Correct.
Okay.
And more importantly, it still falls back on, to be even more clear, you cannot be paid more than you have agreed to in your buyer's brokerage agreement. Not one
Right.
penny, right? So whatever that additional compensation is, if it's a bonus, if it's additional commission, if it's, 3.5% instead of 3, if it's 3 instead of 2, you cannot be paid more than what has been agreed to in that buyer's brokerage agreement. And so if there's anything more you're being paid, you need to go back and modify that buyer's brokerage agreement to add that compensation.
Got it. Okay. Thank you.
Good question. Eliani,
Can you hear me?
I can hear you.
Long time no hearing from you, except
Yeah.
for social media. How are
Great.
you?
I'm good
Looking
at
great.
you.
But
Likewise.
thank you. So 2 questions. The suggestion that you made regarding the retainer, what is a reasonable amount to charge to consumers for sale versus rentals?
So let me give you the legal answer. Number one, that's set by you because we don't want any we call it anti-Sherman Act. That's part of the situation with the Sitzer Burnett case, where, and this as a general matter, guys, when you have professionals that they would call it like they coerce to set the standard or set the fee for a particular service, discussing it in an open forum similar to like this, or in a Facebook group or in a chat, a brokerage chat, you don't want to do that.
Okay.
So my answer to you is, it's up to you. It's up to you. What do you believe that the value of your services are? We never want to try to set a industry standard, because that's exactly part and parcel of this lawsuit, setting an industry standard. We're coordinating to set an industry standard for a particular service, for the cost of a service, and that's what you don't want to do. So that's that. And then number two, even if I said, say for example, so right now we know that the going rate, for example, on average, again, on average, 2.5% for buyer's broker compensation. That doesn't mean you have to do that. Maybe you're like, I get the best. My offers are accepted first round at below market, and I drive my buyers around in a Sprinter, and I make sure they have lunch after they go into contract, and for that reason, my compensation is 7%. Okay,
Oh, Lori, thank you.
but that just, like, no one, as a general matter, guys, you do not have to. You get what you negotiate.
I understand. I'm gonna ask the broker to give me better guidance. And then I will call you regarding that other specific situation that I had with a buyer that allowed me to, help her in so many ways. Even on the weekend while I was on vacation, I was coordinating appointments, paying other agents to show her properties, da da da. And she did pay for some
Don't say too much. This is recorded. Just call
yeah,
me.
yeah. Anyways, and then suddenly overnight she's like, okay, I am no longer
Let's talk
interested.
about it. Let's talk about it offline.
Yeah, okay, perfect.
We don't want
Thank
anybody
you.
trying to connect dots.
Yeah,
Dominica,
thank you.
Okay, quickly. So I'm just trying to see different scenarios. So there is what is it called? When you sign up with the buyer, there's obviously it's up to everyone, but we're using this at Remax that we set $350 to $500 if the buyer decided to cancel on you.
Okay.
To refund, the cost for the pictures, photography, and stuff like that. So, so one case scenario, we're working with the buyer, and buyer suddenly ghost you and go somewhere else, then you find out. Obviously, there's a way that you can enforce it and tell them, okay, you broke the agreement, you have to pay me $500, right? I mean, you just have to, take it to the next level, right?
Mm-hmm.
What is it happens that I decided I don't really want to work with this buyer. It was not working between us.
Mm-hmm.
Can I avoid that $500 and just shake the hand, say goodbye?
Yeah, absolutely.
That's not a problem. And then the next one would be, what if the buyer just comes out with the excuse and says, I don't want to work with you. Okay, so that was the first one that I was just thinking. Okay,
Mm-hmm.
and then what if I decided I don't want to work? Then I can just tell them, bye-bye, right? I mean, everything what we were signed, you don't worry about the cancellation, just leave me alone, right? So
no, you should still cancel it. You should still cancel it.
Yeah. But that's what I'm saying. I cancel it.
Yeah.
But
you mean the fee?
Decided,
yeah, don't worry about the fee. Yeah, they don't have to pay the fee. Sure, correct.
Yeah. But if they decided to cancel with my broker and with us,
you can enforce the fee.
I can enforce the fee. Okay.
Yes.
Okay. Thank you.
And then one other thing I want to say with regards to that is what your rights to enforce are your rights to enforce, meaning, let's say, for example, the buyer's brokerage agreement, they agreed to pay you 3%, but you decide, it was so quick and easy, you only want to be paid 2%. You only require 2%. You can do that, and you don't even have to modify it.
Oh, okay.
So essentially, you don't have to collect everything all that the buyer has agreed to pay you.
So if it's less, you don't. But if it's more, then
you need to modify it.
Got it.
Yeah.
Okay.
Yeah, you need to modify it.
But if they go with other agent behind us back, unless we are able to document it, there's nothing we can do, right? I mean,
yeah, you got to, yeah. You should.
I'm just thinking big picture, obviously, because unless you find out that the house you bought it, then you go check on the MLS and you find out that the new title has a buyer name, which happened to one of my, that was before that was all enforced, but she found out about the house that she showed. It was on the title was the name of the buyer that went with another agent. But that's the only way we really find out, because if they disappear, how do we know what they're doing, right? I mean,
correct.
So that's why not some of the
somebody's gonna that's gonna be the next technology.
But let me ask you, so that's why I run into some agent who says, I don't even enforce buyers, because if they don't want to work with you, they just walk away. There's nothing you can do. But in order to go to the transaction, the buyer agreement has to be presented, correct? That's mandatory, right?
In order to show property, in order to provide real estate services, they call it, which of course services includes even if you're sending them MLS listings, but for sure the trigger is when you show property, whether in person or virtually. Like if you're doing like a Zoom, you must have a document executed.
So if there's an agent who is not enforcing the rules, can they go under the contract with the buyer without signing buyer agreement?
You're not supposed to, no.
Okay.
No, you're not supposed to. I'm not gonna say no, because people apparently last week they said that it's happening all the time. But hey, that's your license and your pockets, because you can be fined. And then again, the brokerages have their own penalties. All right. John Quill and then Lynette, what's going on?
Thank you.
Quick question for the buyer broker agreement. How does that apply to an agent who may be purchasing their own home? Does it apply at all?
Meaning you signing the agreement with yourself, essentially?
No, not necessarily. But if you're going to, I guess, be compensated for the
No, you're thinking. I hear what you're saying. Go ahead, think it through.
Okay, I'll just say it
So
this
what?
way.
Let me restate your question. I like your question. So John Quill's question is: if I'm buying a home, I'm a realtor. I want to collect the compensation for representing myself. How do I do that? Compensation agreement. You don't need a buyer's brokerage agreement. You need the compensation agreement with the seller.
Got it.
Good question. Yeah. Ms. Whitfield, let's go. You're up.
Okay. My question is, I have the listing, and somebody called me and wants to see the property. Go there. Of course, I have no obligation to him. I'm just showing the property, so there's no baby. Correct? Got that. Now he decides that he wants me to write the offer on the property. At what point do I bring the BBA? When I send him
Right
the
then.
contract?
Right
Right
then.
there.
Right
Okay.
then.
Okay. So I should walk with a BBA just in case this person wants to move forward?
Yeah.
Okay.
Yeah.
It's a great
Specifically,
idea, and make sure the BBA is signed before you write any contract.
That's what I wanted to know. Do I make sure it's signed before the contract, or can I send the contract and the BBA at the same time?
no, you want to send it, you want to have the BBA signed before you
Okay.
sign the offer, before you
Thank
prepare
you.
the offer. Yeah. Mhm.
Thank you.
Yeah. That's why I said right then. You want it done right then.
Right there.
Protect yourself, sis. You don't want to be out here working for free.
Yes.
Sabrina.
Okay. Hi, I have a question. I and I have two. I'll put the first one is I was working with a renter. Um, I w- okay. I put in a she signed the agreement on that end. Not a buyer's agreement, but a renter's agreement. So I'll say it that way. She put in a renter's agreement. I reached out to a couple of different places. She said where she was sending me where she wanted to rent. I reached out to them. I asked them would they work with her. She's in Port St. Lucie.
Did you ever do a BBA with her? Did you ever
I did.
Okay, go ahead. Okay.
Okay. So she I reached out to the clients, the sellers that were not sellers, but the renters, the owners of the property for her and her husband, because first they wanted to buy, but then their credit was not good. So I reached out to the people. They said they would work with them because they had some credit wasn't the best. She went to see the property herself without me, and she's signing an agreement. Do the owner of the property still pay me because I reached out to them, and when I spoke with her, I didn't sign anything with the owner of the property, but I did sign it with her. So
It's
will she,
with her. It's with her. I'm glad you
okay.
asked. So that's the answer. Full stop. The enforcement is against her. And I want to highlight exactly what Sabrina just said. I have an agreement signed with the buyer. I do not have any agreement signed with the owner.
Mm-hmm.
What do we need for enforcement?
A contract.
There you go. We need it in writing.
Right.
When I taught this class last year, that was the name of the class, Get It in Writing.
Mm-hmm. Okay.
When I taught this series last year, the series was called Get It in Writing.
Right. So it didn't matter that I sent the sellers the email giving all their information. Okay,
Where
because
did
they
they,
didn't
is
sign
there
it.
anywhere that they agreed to pay you?
No, I don't have it in writing. There you
There you
go.
go. So, I'm glad you're
Okay.
asking the question. I mean, this is what this is all about. And this is similar to even a FISBO,
Okay.
right? You don't go show a property until a FISBO agrees to compensate you, and you're going to use the compensation agreement,
All right. Thank you.
right?
All right. The second one is I am working with the buyer, and it's like pulling teeth with her. She froze up. The contract now we have to re-sign it again. However, if she doesn't move, because what I did with myself, I locked our contract in for a whole year. And I did that for a reason because when I first spoke with her, she told me that she was working with another agent before, and he was pressuring her. So I said, okay, there's no pressure. It's on you. I'm here for you, whatever you would like to do, but I showed her a lot of properties. I made sure she was finished that agreement with him. Now, our contract ended. Actually, it just closed yesterday, where the contract is no longer void, not for us, me and her, but for her property that she was under, because she was under contract. Now we have to redo it again. If she keeps stalling and if she doesn't pay, which I heard you say, she still owes me compensation because of that situation because she's under contract with me for a full year. I covered myself to make sure when
So
I
if I understand what you're saying, so she executed a brokerage agreement for the term of a year. During that term, she went under contract to purchase a property.
right,
And that the closing date was supposed to be yesterday.
correct.
So number one, to answer your question, yes, when she signed that contract, you had earned, under the terms of the agreement, you earned the right to be paid.
Mm-hmm.
Okay, so that's number one. The contract that was supposed to close yesterday, you don't have an extension on that?
We extended it one time before, but she froze. She stopped answering calls. She stopped
So now
answering
she's in
texts and
default.
email. Hmm.
I'm assuming you have an escrow deposit and everything.
Yes.
Okay. Well, here's the deal. There's two separate situations. One, you have earned your commission. However, now you're in a situation where you have to, like Luckner, you have to sue her if you're trying to recover from her.
Hmm.
You got to sue her. Because again, paragraph 7A says closing is not a prerequisite for your fee to be earned.
Okay.
But again, this is why yes, you have that right, but
She's family, so I'm like,
I don't even
I
care
don't
about
want.
that part.
Okay.
I'm trying to figure out the cost. I mean, yes, I shouldn't say that. Let me pull that back and retract that.
you know,
I
it seems like
mean,
every
that's
single one.
important, but and whether it's friend, family, or foe, what you want to always take into consideration is litigation costs. It costs time
Right.
and money.
True.
So even when we have a purchase contract where someone's escrow deposit is on the line, and I say, okay, well, and there we were supposed to close yesterday. Okay, so extend it to give them a couple days or litigate about this escrow deposit because they're not going to sign a release and cancellation, and the escrow deposit is not automatically released, right? So
Mhm.
that's just the point that I'm making, that you're going to have to litigate if you choose to enforce it, and it's time and money. So
Okay. I thank you.
no problem.
I
Any other
appreciate it.
questions? All right. All right. With that being said, I introduced this last week and many of you were not on, so I want to make sure that we are clear on this. All of these, 1 second, I want to work with a couple of sets friends. I want to buy here in Florida. They mentioned they got family over here. I was wondering, do I have the family inside here, even though they are about. Nope, you're going to have your buyer sign it. That's a good question. Question in the chat is, um, agent has a buyer that is currently not located in Florida. They're going to have someone, again, like paragraph 7A says, acting on their behalf to go and see the properties physically for them. Should the agreement be signed with the person that's touring the properties on behalf of the buyer or by the actual buyer? It needs to be signed by the actual buyer. That is a very good question, Jessica. It needs to be signed by the actual buyer because the buyer is the one that you're going to seek to enforce the agreement against in the event that there is an issue. All right, good. All right,
Would you
so
do, Raquel? I have a
yeah.
question. Sorry, I didn't raise my hand. Sabrina has her hand up first.
No, she's done.
You guys just went over. Say that you are showing though for on behalf of the potential buyer to someone else on their behalf. Do you do a showing agreement with them?
No, because
Okay.
again, it's all about who you're going to seek to enforce the terms of the agreement against.
Right, have a buyer brokerage agreement with the buyer, but have a showing agreement with the person you're
No,
showing it
because
to. No, okay,
you're not going to try and enforce anything against that person.
okay.
That's a good question. Good clarification. You're not seeking to enforce against that person. You are seeking to let me- this yeah, against the buyer, the
Understood.
actual eventual buyer. All right.
Thank you.
No problem. Very good question. You guys did a very good job today, and you asked a lot of good questions, and you guys have just further enforced my position that I am really forging this year. And that is my declaration that leads do not close themselves. Leads do not close themselves. That's my quick statement for this year. And the reason I said is because guess what? You have to know how to work the transaction. And all of this is part of the transaction. So someone shows up today and they say, I want to work with you, Patricia, you're great. You're great. Marketing is surface level. Transaction mastery is below the surface. The real skill starts after the person raises their hand and says that they want to work with you. So all of these questions that you guys have asked, they come behind the marketing. It's the transaction mastery. And it is the part I get very emphatic and like animated about this because the questions that you guys are asking, they're all fantastic questions. And I get these questions probably times 10 every day. So we're going to make sure. I don't want to be the ones that complaining about something and not providing a solution. This year, Purchase Ready Lab, our focus is transaction mastery. That is, how do we actually do the work? How do I actually do the work? Someone raised their hand. They say they want to work with me. They say they want to see a property. How do I now do the work? And this goes from the BBA and listing agreement all the way to closing. What we're seeing online a lot is social media. Oh, I can show you how to market yourself. But guess what? That's just the tip of the iceberg. Beneath the surface is 90% of the job. That's what's going to drive the transaction to closing. If you don't know how to do that, then the leads don't matter, right? If you freeze up when a client asks you the tough questions, you don't know how to navigate negotiations, you don't know how to navigate consultations for buyer's agreements being executed, listing agreements being executed, negotiations for inspection results, appraisal, lenders, and extensions, then the leads don't matter. You can buy leads, but you cannot buy transaction mastery. And so I was having this conversation and check this out. This came up and this is a realtor, probably out of the Northeast because of her accent, but she said it for me.
So the other day I went to a realtor class on how to use Instagram. You know, when I started real estate, which was a million years ago, we used to go to classes on how to calculate buyer's loan payments and how to figure out what someone's house was worth, things that might be important to the buying and selling of real estate. But now I go to a class where I learn not to use hashtags anymore because they're so last year. You know, let's kind of go back to when realtors actually knew about real estate. What do you think?
What do you think? And of course, on the screen, we have a bunch of people that are agreeing with her entirely. Knowing how to do with real estate is transaction mastery. That's it. How do I actually complete the transaction? So with that being said, that's what we're building this year. On the screen, I have a QR code. Also, if you go to purchaseredylab.com survey, it's a quick survey. So for those of you who've already completed it last week, greatly appreciate it. I am excited to share the results with you. But for those of you who did not have an opportunity to complete this survey last week, if you're just joining us this week, I would greatly appreciate it if you would complete this survey. This will allow us to develop the curriculum that's going to help you. Now, I can tell you guys from the seat that I sit in, like I told you before, I have a 360-degree view and I get all the questions. But I want to know for sure, for those of you that show up, those of you that actually are going to utilize content, what do you need help with, right? So if you complete that survey, that will help tremendously. Next week, we're going to go over buyer consultation and hopefully we'll not go 40 minutes over. Do you guys know the intent is for these classes to really be 45 minutes? But again, this just goes to show you how much is beneath the surface of marketing. These classes are supposed to be 45 minutes. We are an hour and 37 minutes in, but I enjoy it. You guys are, if you getting value out of it, then I'll hang out as well. But next week, same place, same time, we're going to go over the buyer consultation. All right. If you signed up for today, then you should receive the link for next week. I'm almost positive. If not, go back and sign up. All right.
You're the best.
All right, guys.
Thank
That
you.
is, thank
Is
you.
Title Expert still open for business?
Absolutely.
Okay.
Absolutely. We're still open. We're actually in the process of all of our brands are going to be under purchase ready. Title Experts is absolutely still
Well, definitely keep us updated because I'll be putting you on the contracts, whether they go through or not.
Oh, yes, ma'am. Title experts, closings at titleexperts.com.
Let's go.
Yes, I hope to see you soon. I have 3 on the market right now and 1 more to go.
This girl be busy. This is a little listing machine. This is a sleeper. Y'all don't see her posting everywhere, but she get them done. All right,
Thank you,
guys.
ma'am.
This is great. This has been great. I will see you all. You're welcome. Good to see you, Ms. Whitfield. I'll see y'all next week. All right. Bye-bye.
Thank you.
Bye.